This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. The name Jeffrey Epstein is often surrounded by speculation, theories, and noise. This series begins somewhere else, with the official record. According to documents released by the U.S. Department of Justice, Jeffrey Edward Epstein was a financier who became the subject of multiple federal investigations spanning decades. What separates this case from many others is not only the severity of the allegations, but the volume of records, plea agreements, sealed filings, and internal correspondence that now exist in the public domain. This file does not attempt to reconstruct rumors or internet narratives. It examines what was formally documented, when it was documented, and by whom. DOJ records show that Epstein first entered the federal system long before his name became widely known. Early reports, filed complaints, and internal memoranda reveal a pattern of attention from law enforcement that began years before his 2008 non-prosecution agreement. These records establish a paper trail, one that raises questions not through accusation, but through chronology. Public filings indicate that Epstein maintained residences in multiple jurisdictions, traveled extensively, and interacted with individuals across finance, academia, and politics. The documents do not assign criminal liability to those associations. They do, however, confirm that these connections were known to investigators and recorded in official files. The Department of Justice disclosures include timelines, correspondence between agencies, and references to investigative decisions. Some pages are fully visible. Others are partially redacted. The redactions themselves are part of the record, signaling information deemed sensitive, protected, or unresolved. What matters in this opening file is scope. This is not a single case. It is a network of filings, decisions, delays, and reversals that unfolded across years and jurisdictions. As this series progresses, each part will examine a different layer of the official record, starting with who Epstein was on paper, not in public myth. Because before examining the deals, the flights, or the failures, the record asks a simpler question. How did this case begin? And what did authorities know at the start? That question appears, repeatedly, across the earliest DOJ documents. And it leads directly to the next file. According to publicly released records and reporting referenced in Department of Justice files, Jeffrey Epstein did not begin his career in finance as a known public figure. The earliest documents describe a man operating largely outside traditional financial institutions, yet gradually gaining access to elite social and professional circles. Epstein's name first appears in official records in connection with his employment history. Court filings and background summaries indicate that he worked briefly as a mathematics teacher in the 1970s before transitioning into finance. DOJ reference materials do not describe a clear, conventional path explaining how this transition occurred. What is documented is that, by the early 1980s, Epstein was managing significant sums of money for high-net-worth individuals. Financial records cited in later investigations show that Epstein's wealth structure was unusually opaque. He was not publicly listed as the head of a major investment firm, nor did his entities regularly file disclosures typical of large financial institutions. Despite this, multiple records confirm that Epstein owned private aircraft, luxury properties, and offshore-linked financial accounts. DOJ-related filings and court exhibits reference Epstein's associations with prominent figures in finance and academia during this period. These associations, as documented, are not presented as criminal acts. However, they establish that Epstein's access to influential environments was known, recorded, and in some cases noted by investigators reviewing his background years later. By the mid-1990s, Epstein's name appears more frequently in civil records, property transactions, and travel documentation. These records show an expansion of his physical footprint, residences in New York, Florida, and later the U.S. Virgin Islands. Each location would later become relevant to federal jurisdictional questions. Importantly, DOJ disclosures indicate that federal authorities did not retroactively reconstruct Epstein's rise. Much of this information existed in real time, preserved in financial summaries, background checks, and internal references long before his first criminal case reached public attention. What emerges from the documents is not a sudden ascent, but a gradual accumulation of wealth, mobility, and insulation from scrutiny. The record does not explain how Epstein achieved this protection. It simply confirms that it existed. And as the paper trail grows denser, the first formal complaints begin to appear, quietly, locally, and without public notice. Those complaints mark the point where Epstein's documented rise intersects with law enforcement attention. According to records later referenced in Department of Justice filings, the earliest documented allegations against Jeffrey Epstein did not originate at the federal level. They began locally through reports and complaints that initially received limited attention beyond their immediate jurisdictions. Court records and investigative summaries show that, in the early 2000s, law enforcement in Florida began receiving reports involving a wealthy individual accused of inappropriate conduct with minors. These reports were formalized through interviews, written statements, and internal police documentation. At the time, Epstein was identified by name, address, and known residences. DOJ released materials indicate that these early complaints were not anonymous tips. They included sworn statements, corroborating accounts, and references to specific locations. Local investigators compiled evidence that was later summarized in case files reviewed by state and, eventually, federal authorities. What stands out in the record is timing. The complaints were logged, categorized, and preserved years before Epstein's name entered national media coverage. Internal references show that these files existed in law enforcement systems while Epstein continued to travel, acquire property, and maintain his public lifestyle. According to investigative documents, the transition from local inquiry to federal awareness was gradual. There is no single moment in the records where the case is marked as escalated. Instead, DOJ materials reflect a series of handoffs, summaries forwarded, meetings noted, and jurisdictional questions raised. Some of the earliest interview notes referenced in later filings describe consistent patterns reported by multiple individuals. These notes are cited in DOJ-related case reviews, though portions remain redacted to protect victim identities. The redactions themselves indicate that the material was considered sensitive, but credible enough to warrant long-term preservation. Importantly, the official record does not show immediate prosecutorial action following these allegations. Instead, it shows evaluation, internal discussion, and delay. Decisions appear to have been shaped by jurisdiction, evidentiary thresholds, and prosecutorial discretion rather than public pressure, which at the time did not exist. By the time federal authorities became formally involved, much of the foundational material had already been created. The DOJ did not generate these allegations, it inherited them. And with that inheritance came a critical question reflected repeatedly in internal documents. What should be done with a case that already exists, but has not yet been pursued? That question sets the stage for the next phase of the record, where informal review turns into formal negotiation. Department of Justice records indicate that once the early allegations were compiled and reviewed at the local level, they did not remain confined to police departments. Summaries, witness statements, and evidentiary outlines were gradually transmitted to prosecutorial offices, where decisions shifted from investigation to legal strategy. According to DOJ-referenced filings, this transition marked a significant change in how the case was handled. Prosecutors were no longer assessing whether allegations existed that had already been established. Instead, they were evaluating how the case could proceed within the constraints of jurisdiction, statute, and evidentiary burden. Internal correspondence cited in later DOJ disclosures shows that meetings took place between local prosecutors, federal representatives, and law enforcement agencies. These discussions focused on charge selection, potential exposure, and the viability of federal involvement. Some of these communications are fully visible in released documents. Others are partially redacted, indicating deliberations considered sensitive at the time. What is notable in the record is that federal prosecutors were aware of the scope of the allegations before any formal plea discussions began. DOJ materials reference victim counts, corroborating testimony, and investigative summaries that outline potential federal charges. These references appear repeatedly across internal memoranda reviewed years later. Despite this awareness, the record shows a cautious approach. Prosecutorial notes reflect concern over witness cooperation, trial risk, and legal complexity. The documents do not indicate disbelief of the allegations. Rather, they reflect a calculation: how likely a case was to succeed, and at what cost. During this period, Epstein's legal representation also enters the official record. Filings and correspondence confirm that defense attorneys were actively communicating with prosecutors while investigative reviews were still ongoing. These interactions are documented through letters, meeting notes, and references in DOJ summaries. What emerges from this phase of the record is a narrowing of options. While early investigative files suggested multiple potential avenues, prosecutorial discussions increasingly centered on negotiated outcomes. The possibility of trial is mentioned, but it is no longer the dominant focus. This shift, from investigation to negotiation, is clearly visible in the documents. And it marks a turning point. Because once negotiations begin, the shape of a case can change permanently. The DOJ record reflects that moment quietly, without headlines or public scrutiny. And it leads directly to the decision that would later define this case in the public eye. According to Department of Justice records and court filings later made public, the period following prosecutorial review was dominated by negotiation rather than litigation. This phase culminated in what became known as the 2008 Non-Prosecution Agreement, a document that would later be scrutinized across legal, political, and public forums. DOJ materials indicate that federal prosecutors in the Southern District of Florida engaged in extended discussions with Epstein's legal team while evaluating potential charges. Internal memoranda referenced in later disclosures show that these discussions occurred alongside ongoing assessments of evidence, witness availability, and legal risk. The record reflects a deliberate, structured process, not an abrupt resolution. What distinguishes this agreement, according to DOJ reviews conducted years later, is its scope. The non-prosecution agreement did not merely resolve federal charges under consideration at the time. It also included provisions affecting potential co-conspirators and limited future prosecutions related to the same conduct. These terms are explicitly outlined in the agreement and confirmed in subsequent court opinions. Importantly, DOJ documents show that the agreement was finalized without direct notification to identified victims during the negotiation phase. This omission would later become central to legal challenges and internal reviews. At the time, however, the agreement was treated as a lawful exercise of prosecutorial discretion, documented through signed filings and internal approvals. Epstein's plea in state court followed shortly thereafter. According to court records cited by the DOJ, he pleaded guilty to state-level offenses and received a sentence that included incarceration, work release, and registration requirements. These outcomes were formally recorded and publicly accessible, though their implications were not widely discussed at the national level at the time. The DOJ record does not suggest that prosecutors believed the allegations to be minor. Instead, it reflects a judgment that the negotiated outcome was preferable to the uncertainties of trial. That judgment, preserved in documents and correspondence, would later be revisited under intense scrutiny. Years after the agreement was executed, the Department of Justice conducted internal reviews examining how and why the decision was made. Those reviews did not retroactively alter the agreement, but they acknowledged procedural concerns and failures in communication with victims. The documents show that this agreement effectively closed the case, on paper. But closure in the record did not mean resolution in reality. Because while the legal process paused, the paper trail did not end. And as subsequent filings would reveal, the consequences of this agreement continued to shape every stage of what came next. Department of Justice records show that the 2008 agreement did not mark the end of official awareness regarding Jeffrey Epstein. While the case was considered resolved within the scope of that agreement, federal and state agencies continued to generate records referencing Epstein in the years that followed. According to DOJ-released materials, Epstein remained on the radar of multiple agencies due to registration requirements, civil litigation, and ongoing information sharing between jurisdictions. These records include compliance reports, travel documentation, and references to civil depositions that were preserved in federal systems even as no new criminal charges were pursued at the time. One significant development documented in DOJ-related filings is the emergence of civil lawsuits brought by victims. These cases, filed independently of criminal proceedings, produced sworn testimony, discovery materials, and court rulings that expanded the factual record. Federal agencies did not control these cases, but DOJ summaries later cite them as part of the broader evidentiary landscape. Internal DOJ reviews indicate that information from these civil proceedings was known to federal authorities. Depositions, affidavits, and judicial findings were cataloged, referenced, and in some instances analyzed for potential relevance to federal jurisdiction. The record reflects awareness, but not immediate action. During this period, Epstein's movements continued to be documented. Travel records, property filings, and financial disclosures referenced in later DOJ reviews show that he maintained access to private aircraft and multiple residences. These activities were not hidden from regulatory systems, they were logged, processed, and stored. What stands out in the documents is the contrast between visibility and intervention. Epstein was not operating in secrecy. His compliance status, travel, and legal engagements generated routine paperwork. Yet the record shows no renewed criminal prosecution during these years, despite the accumulation of additional sworn testimony in civil courts. DOJ materials also reference internal discussions that occurred after the agreement, particularly as public criticism began to surface years later. These discussions focused on the limits of the original agreement and whether it constrained future action. The answers, at the time, were largely procedural. The file shows that the agreement created a legal boundary, one that agencies recognized, debated, and ultimately respected until new jurisdictional grounds emerged. That boundary would not be tested immediately. But the documents suggest that the case was never fully dormant. It was paused, contained, and monitored, waiting for a trigger that would reopen federal scrutiny. That trigger would come years later, from outside the original case. As Department of Justice documents related to Jeffrey Epstein were reviewed, released, and later re-examined, one feature appeared consistently across the record: redaction. Blacked-out names, removed paragraphs, and sealed attachments are present in filings spanning years and jurisdictions. According to DOJ disclosure guidelines, redactions are applied to protect victim identities, ongoing investigative methods, grand jury material, and information deemed sensitive under federal law. In the Epstein files, all of these categories appear. The result is a public record that is extensive, yet incomplete by design. DOJ released correspondence and court exhibits show that entire sections of memoranda were withheld from public view. In some cases, only headings remain visible, indicating discussions that took place but are not fully disclosed. These gaps are not random. They appear in consistent locations, references to third parties, internal deliberations, and parallel investigative activity. Importantly, the presence of redactions does not imply wrongdoing by those named or unnamed. The documents themselves do not make that claim. What the redactions do confirm is that information existed, was recorded, and was considered significant enough to protect. In several DOJ summaries, references are made to attachments or exhibits that are listed but not included in public releases. These references suggest supporting material, interview transcripts, evidentiary exhibits, or interagency communications that remain sealed. The record acknowledges their existence without revealing their contents. Federal court rulings cited by the DOJ also address disputes over disclosure. Judges weighed privacy, due process, and statutory limits when determining what could be released. In multiple opinions, courts affirmed that the public record would remain partial, even as transparency increased. The pattern across these documents reveals a layered file. What is visible establishes timelines and decisions. What is hidden signals areas of continued sensitivity. Together, they form a record that is both informative and restrained. This duality matters. The Epstein case is often discussed as if everything is known. The DOJ record shows otherwise. Even after years of litigation and disclosure, portions of the file remain inaccessible to the public. These gaps shape interpretation. They limit certainty. And they remind viewers that official records are governed not only by what is revealed, but by what is withheld. Understanding where the record stops is as important as understanding where it speaks. Because beyond these redactions lie questions that cannot be answered through speculation, only through documented change in status. That change would arrive abruptly, forcing the case back into federal jurisdiction. According to Department of Justice records, federal attention returned to Jeffrey Epstein years after the 2008 agreement due to new legal circumstances rather than a reversal of earlier decisions. The reopening of the case did not stem from speculation or public pressure alone. It was triggered by jurisdictional changes and the emergence of conduct that fell outside the scope of the original agreement. DOJ filings indicate that by the mid to late 2010s, federal authorities in New York began reviewing information related to Epstein that had not been covered by the Florida resolution. These reviews focused on timeframes, locations, and potential violations distinct from those previously addressed. The record shows that this distinction was central to re-establishing federal jurisdiction. Investigative summaries referenced in DOJ disclosures note that prosecutors examined travel records, financial transactions, and witness statements tied to New York-based activity. These materials were not retroactive reinterpretations of the Florida case. They were treated as a separate factual record, evaluated under a different prosecutorial authority. During this period, civil litigation continued to generate sworn testimony and documentary evidence. DOJ released summaries confirm that federal prosecutors monitored these developments closely. Depositions and filings from civil cases were analyzed for relevance, not as conclusive proof, but as potential sources of corroboration. What changed most visibly in the record is posture. DOJ documents show a shift from monitoring to active investigation. Grand jury subpoenas were issued. Witnesses were interviewed under federal authority. Evidence was gathered within a clearly defined jurisdictional framework. Importantly, the documents emphasize that the renewed investigation did not nullify the earlier agreement. Instead, it operated alongside it, constrained by its terms but not governed by them entirely. This distinction appears repeatedly in DOJ memoranda and court filings. By the time Epstein was formally charged in the Southern District of New York, the DOJ record reflects a case built carefully around procedural boundaries. The charges filed were specific, limited, and grounded in conduct prosecutors believed could be proven independently. The reopening of the file was not sudden. It was deliberate, documented, and legally narrow. And once the case returned to federal court, it moved quickly. Because unlike the earlier phase, this time the proceedings unfolded under national. Even with federal charges filed and documents released, the Department of Justice record remains defined as much by its silences as by its disclosures. DOJ filings repeatedly emphasize what can be proven in court, not what may be suspected, rumored, or implied. This distinction shapes the limits of the official narrative. One of the most notable gaps involves third parties. DOJ records acknowledge the existence of extensive contact lists, flight logs, and financial transactions, yet they stop short of assigning criminal liability beyond Epstein himself. The absence of additional charges is not explained in detail. Instead, filings consistently return to evidentiary standards and prosecutorial discretion. Internal memoranda released in redacted form make clear that investigators evaluated information related to other individuals. However, the documents also stress that association alone does not meet the threshold for prosecution. The record reflects repeated assessments of credibility, corroboration, and jurisdiction, often without revealing outcomes. Another unresolved issue concerns scope. DOJ summaries confirm that evidence existed spanning multiple years and locations, but the charges ultimately filed addressed a narrow window of conduct. Prosecutors justified this limitation by referencing statutes of limitation, venue constraints, and the availability of witnesses willing to testify under oath. The record also does not fully explain timing. DOJ documents outline when investigative steps occurred, but they offer little insight into why certain actions were taken when they were. Delays are attributed broadly to legal complexity rather than specific decisions or individuals. Perhaps most striking is how frequently DOJ filings rely on procedural language. Terms like insufficient evidence, unable to corroborate, and outside prosecutorial scope appear repeatedly. These phrases signal legal boundaries, not factual conclusions, a distinction often lost in public interpretation. After Epstein's death, DOJ documents narrow further. Reviews focused on custodial procedures, jail protocols, and institutional failures rather than the underlying criminal investigation. The shift in focus effectively closed the prosecutorial record without resolving broader questions. What remains is an official account that is internally consistent but incomplete. The DOJ record explains what the government could pursue. It does not explain everything the government knew, suspected, or reviewed. This gap between public expectation and legal documentation is not accidental. It is structural. And it is why the Epstein case continues to generate questions long after formal proceedings ended. The Department of Justice record on Jeffrey Epstein was never intended to be a complete historical account. It was not written to answer every public question, resolve every theory, or document every allegation. Its purpose was narrower, more rigid, and strictly legal: to define what could be charged, proven, and defended in federal court. Across indictments, memoranda, court filings, and post-case reviews, a consistent theme emerges. The DOJ record prioritizes process over narrative. Each decision is framed through jurisdiction, evidentiary standards, and procedural limits. What falls outside those boundaries is not denied, it is simply excluded. This is why the record often feels unsatisfying to the public. It does not confirm suspicions, nor does it validate speculation. It explains actions taken, not moral judgments. It documents steps followed, not hidden motives. In legal terms, it is complete. In human terms, it feels unfinished. DOJ documents repeatedly stress independence. Investigations are compartmentalized. Cases are built in isolation. Liability is individual, not associative. These principles protect the integrity of prosecutions, but they also narrow the scope of accountability reflected on paper. After Epstein's death, the record effectively closes itself. The DOJ's focus shifts away from criminal liability and toward institutional review. The prosecutorial narrative ends not with a verdict, but with a procedural conclusion. No trial, no cross-examination, no final evidentiary record tested in court. What remains, then, is not a revelation but a framework. The DOJ record tells us what the justice system did, and what it could not do, within its own rules. It does not claim to reveal the full truth. It claims only to document the legal truth. This distinction matters, because understanding the Epstein case through DOJ documents alone means accepting their limitations as intentional, not accidental. The gaps are not always cover-ups. Often, they are boundaries. And that is the uncomfortable reality of the official record. It answers the question of prosecution, but not the question of closure. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.